Hello, everyone. Thank you so much for through our tech difficulties. I'm just waiting for folks to rejoin here, and then we'll get started. Hello, everyone. Thank you so much for sticking with us. We're just waiting on folks to join. Long story short, ELI was having trouble with our Zoom account, so we had to direct folks to this new Zoom webinar, so we're just waiting on people to join. We so apologize for this issue, and we thank you so much for your patience. While we get this resolved, our moderator is with us, so I'm going to go ahead and introduce her and kick things off while ELI works on the back end to make sure that everyone is admitted into this new webinar. So thank you all so much for joining us today. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at ELI. I wanted to give a warm welcome to today's event, and thank you so much for joining us today. We appreciate your time and engagement. I also want to give a huge thanks to our fantastic speakers who've put time into preparing an informative and interesting program for you all today. So thank you so much to our speakers for their time and energy. Today's webinar is the final rule about the final rule that was issued to revise the waters of the United States, often referred to as WOTUS definition rule, which was released on August 29th. We also held a webinar earlier this summer on the Sackett v. EPA Supreme Court decision, which is what influenced this final rule. So if you're interested in watching the webinar we held featuring some of today's panelists, ELI has made a recording publicly available for the next couple of weeks. We'll post that link in the chat. Today's program will feature short presentations by each panelist, followed by a roundtable discussion with time at the end for audience Q&A. So if you do have any questions at all, please put them in the Q&A box. You don't need to wait until the end, though. Please submit them as soon as you think of them through Zoom's Q&A function. Should you have any technical issues during the webinar, please message the ELI team or email events@eli.org. This webinar will be recorded, so if you're unable to view the entire program, you can find it on ELI's webpage within a few business days of the event. You'll need to be logged into your ELI account in order to access the program, though. Should you have any issues accessing the recording, you can also email us. And with that, I will hand things over to our wonderful moderator, Rebecca Kihslinger. Rebecca is the Senior Science and Policy Analyst at the Environmental Law Institute and Director of ELI's Wetlands Programs. Rebecca, I will hand things over to you, and we'll get the slides up momentarily. And once again, I apologize so much for this technical issue. We are able to keep the webinar going past 1:30 if our panelists are able to. And again, this will all be posted to the website if you're unable to watch all of it. Thank you so much, and over to you, Rebecca.
Awesome. Thank you so much, Madison. We appreciate it. Thank you all so much for your patience. I promise our speakers are going to deliver, and it's going to be great information, and it'll be worth the wait. So thank you again for your patience, and we're happy to have you. Madison, I'm not able to turn on my camera. We got there. Hi. Okay. So as Madison said, my name is Rebecca Kihslinger. I am the Senior Science and Policy Analyst at the Environmental Law Institute, and I direct our Wetlands program. ELI's Wetlands program provides timely, balanced information on wetlands law, policies, science, and management through research, education programs like today's webinar, and convenings. And we can go to the next slide. So over the past 50 years and throughout recent changes in the definition of waters of the U.S., ELI has prepared authoritative research and analysis on federal, state, and tribal wetlands and water laws, and hosted numerous workshops and webinars focused on legal and programmatic means for wetland protection. This webinar, as Madison mentioned, is part of a series of resources that ELI has been able to provide leading up to and following the Supreme Court's recent decision in Sackett v. EPA, which significantly redefined the Clean Water Act's coverage of waters of the U.S. Some of these resources include an ELI Vibrant Environment blog, which we posted very shortly after the decision came down, on 6 consequences of Sackett v. EPA. It's really worth a read if you haven't yet done that. The next 2 are resources focus on states and draw on our extensive body of research in that area. The first is an Environmental Law Reporter article. It focuses on states' ability under their existing law to regulate dredge and fill activities in non-federal waters. The second is a companion piece called Filling the Gaps. It does summarize that regulatory information, and we also detail some other kinds of approaches that states and local governments and others are taking to protect waters in their state or jurisdiction. And finally, as Madison mentioned, we had an ELI breaking news webinar shortly following the Sackett v. EPA decision. We detail we kind of dive deep in that Sackett decision and have a number of experts analyze what we can look for and the consequences and looking ahead for the future of wetland protection. All of these resources are available on ELI's website. I've included my contact information here on this slide. If you have any questions or follow-up, please feel free to contact me on any of these resources or other parts of the wetlands program at ELI. And we can go to the next slide. So why we are here today. Last week, US EPA and US Army Corps of Engineers conforming rule, which amended the agency's January 2023 revised definition of WOTUS rule, was published in the Federal Register and made immediately effective. Among other things, the conforming rule made a number of amendments to the January 2023 rule, taking cues from that Sackett decision. So these included things like removing the significant nexus standard that was first articulated by Justice Kennedy's 2006 Rapanos concurrence. It revised the definition of adjacent to meaning having a continuous surface connection from the long-standing definition of bordering, contiguous, or neighboring. It also removed interstate wetlands from the category of interstate waters. So today we're going to dive deep or a little deeper into this conforming rule and talk about some of these issues and the changes that were made. And we've convened a really stellar panel of 4 experts, and we thank you again for your time and patience, who we're going to discuss the development of the conforming rule, and where they're going to provide their unique perspective on the rule's on-the-ground implications. So we thank you, panelists, for being here. We thank you, audience, for being here. I'm going to introduce each speaker as we go through their presentations, and we're going to save most of the questions for the end. But as Madison mentioned, please do put them in the Q&A now. Don't wait. If something comes up in a presentation, go ahead and put that in, and then I can ask those at the end. So thank you for doing that. So with all of that, I'm going to turn to our first speaker, who's Brian Frazer. He's the Director of EPA Office of Wetlands, Oceans, and Watersheds. Brian's going to provide a high-level discussion of the conforming rule, how it was developed in response to the Sackett decision, and offer some insight into what EPA and the agencies have planned for next steps. So off to you, Brian. Thank you so much.
All right. Thank you, Rebecca. Good afternoon. My name is Brian Frazer, and I am the Director of EPA's Office of Wetlands, Oceans, and Watersheds. I would like to start today's presentation by providing some background on the definitions of waters of the United States, including covering recent events. Then I'll review the conforming rule that amends to the January 2023 definition of waters of the United States. Finally, I would like to discuss next steps and available resources. Next slide, please. Waters of the United States is a threshold term in the Clean Water Act that establishes geographic scope of federal jurisdiction under the Act. The Clean Water Act does not define waters of the United States. EPA and the Department of Army have defined waters of the United States through regulations since the 1970s. Next slide. This slide highlights key regulatory changes and Supreme Court cases over time that have affected the definition of waters of the United States. To set the stage, note that the long-standing regulations defining waters of the United States were established in 1986 and 1988 by the Corps and EPA, respectively. U.S. Supreme Court opinions came in 1985, 2001, 2006, and 2023. I would like to focus on Rapanos specifically for just a moment. In 2006, the Supreme Court established 2 different standards for determining jurisdiction in the consolidated cases known as Rapanos, and did not invalidate the underlying regulations. In a 4-1-4 decision, the court created 2 tests for jurisdiction. Under the Scalia plurality opinion, the test was whether a water was relatively permanent and connected to traditional navigable waters, or whether a wetland had a continuous surface connection to such water bodies. Under the Kennedy concurrent opinion, the test was whether a water had a significant nexus to waters that are navigable in fact. Under the Rapanos guidance issued in 2007 and revised in 2008, the agencies could use either test to establish jurisdiction. Then on May 25th, 2023, the Supreme Court issued a decision in Sackett versus EPA, which brings us to where we are today. Next slide, please. Let's briefly cover some of the more recent events. The January 2023 rule, which is called the Revised Definition of Waters of the United States, published in the Federal Register January of this year. The rule took effect 60 days later on March 20th, 2023. In June, EPA and Army announced our plans to issue a final rule to amend the January 2023 rule consistent with the Sackett decision that was issued in May. We issued that rule at the end of August, and the rule published in the Federal Register on September 8th, 2023. The rule was effective immediately upon publication in the Federal Register. Next slide, please. The map on this slide illustrates which definitions of waters of the United States is generally operative in each state across the country as a result of litigation challenging the 2023 rule. As a result of ongoing litigation on the 2023 rule, the agencies will implement the January 2023 rule as amended by the conforming rule in 23 states, the District of Columbia, and the U.S. territories. In the other 27 states, and for certain parties, the agencies are interpreting waters of the United States consistent with the pre-2015 regulatory regime and the Supreme Court decision in Sackett until further notice. Next slide, please. Let's discuss the Sackett decision itself. It's important to note that the January 2023 rule itself was not directly before the court in Sackett. However, the court did consider the jurisdictional standards that was set forth in the January 2023 rule, including the relatively permanent standard and the significant nexus standard. The Supreme Court concluded that the significant nexus standard was inconsistent with the court's interpretation of the act. The court also concluded that the Rapanos polarity was correct, that the term waters used in the Clean Water Act encompasses only relatively permanent standing or continuous flowing bodies of water, including streams, oceans, rivers, and lakes. For wetlands, the court also agreed with the polarity that to be jurisdictional, wetlands must have a continuous surface connection to water bodies that are waters of the United States in their own rights so that there is no clear demarcation between waters and wetlands. Based on the court's decision, EPA and Army determined that the regulatory text of the January 2023 rule needed to be amended. The agencies have been clear since Sackett decision, we are interpreting the definition of the waters in the United States consistent with Sackett. Next slide, please. Good cause. Now that we have covered the background, I'll provide an overview of the conforming rule that amends the January 2023 definition of waters of the United States. The Administrative Procedures Act allows agencies to issue rules without prior proposal and opportunity for comment if there's good cause for doing so. In this case, the agencies have determined that such notice and opportunity for comment is unnecessary. In this instance, certain provisions in the January 2023 rule are invalid under the Supreme Court interpretation of the Clean Water Act and the Sackett decision. And the agencies have responded by amending the definitions of waters of the United States to reflect the decision. Providing public notice and seeking comment is unnecessary because the sole purpose of the conforming rule is to amend these specific provisions of the January 2023 rule to conform with Sackett, and such conforming amendments do not involve exercise of the agency's discretion. Next slide, please. Let's talk about the preamble. I would like to provide some information about the preamble to the conforming rule. The preamble covers 4 topics listed on the slide. First, why are the agencies issuing the rule? Second, which provisions are amended? Third, the preamble includes a section on severability where the agencies clarify that in the event of a stay or invalidation of any part of this rule, the agency's intent is that the remaining portions of the rule can be continued to operate independently. Finally, the preamble includes the standard statutory and executive orders reviews section. Next slide, please. I would like to highlight a couple of specific parts of the preamble to the conforming rule that are relevant to implementation and the agency's future plans regarding potential additional actions and stakeholder engagement. First, the preamble notes that the agencies will continue to interpret the definition of waters of the United States consistent with the Sackett decision. Second, the preamble notes that the agencies have a wide range of approaches to address any issues that may arise outside of this limited rule, including approved jurisdictional determinations and the Clean Water Act permits, guidance, notice and comment rulemaking, and agency forms and training materials. The preamble is also clear that we intend to hold stakeholder meetings to get public input and other issues to be addressed. Next slide, please. The next few slides provide information about the contents of the conforming rule. As a reminder, with this rule, we are making targeted changes to the January 2023 rule. This slide lists the categories of paragraph A, jurisdictional waters included in the January 2023 rule, which are being retained. 3 categories of water in the January 2023 rule explicitly state that they are jurisdictional if the waters meet either the relatively permanent standards or a significant nexus standard. These include A3 tributaries, A4 adjacent wetlands, and A5 additional waters. In the conforming rule, amending the January 2023 rule, the agencies are deleting the significant nexus standard from these categories as the basis of jurisdiction. The agency is also revising the interstate waters provision to remove interstate wetlands. Under Sackett, the provision authorizing wetlands to be jurisdictional simply because they are interstate is invalid. Finally, the agencies are revising the A5 additional waters provision to remove streams and wetlands. As a result of the decision in Sackett, invalidating the significant nexus standard, the provision for assessment of streams and wetlands under the additional waters provision of paragraph A5 is no longer valid, as any jurisdictional stream and wetlands are covered by paragraph A1 through A4 of the January 2023 rule. Therefore, the agencies are deleting streams and wetlands from this provision. Next slide, please. On the exclusion, the agencies are not changing any of the paragraph B exclusions, including the January 23 rule. The 8 exclusions are listed here on the slide for your reference. Let's get time to look at them. All right, and so next slide, please. Definitions. This slide lists the paragraph C definitions, including the January 2023 rule. The agencies are amending the definition of adjacent and deleting the definition of significantly affect based on Supreme Court decision in Sackett. The other definitions remain the same. The agencies are revising the definition of adjacent to read, adjacent means having a continuous surface connection, which is narrower than the agency's longstanding definition of adjacent. The agencies are deleting the definition of significantly affect altogether, since the definition was only relevant to the significant nexus standard. Next slide, please. Let's briefly discuss the approved jurisdictional determinations, or AJDs, issued by the Corps of Engineers. After the Sackett decision was issued, the Corps paused the issuance of all AJDs while the agency determined next steps. However, after a short time, the Corps did begin issuing some types of AJDs. These included dry land AJDs where there were no water resources involved at all. These also included AJD features that meet the terms of the exclusion under the 2023 rule or the pre-2015 regulatory regime where applicable. On September 8th, 2023, the effective date of the conforming rule, the Corps resumed issuing all types of AJDs. Next slide, please. So the impacts of Sackett. Let's cover a key question that the agencies have received from many stakeholders since the Sackett decision was issued. How many waters are no longer jurisdictional under the Sackett decision and the agency's amended 2023 waters rule? The agency's conforming rule is simply updating specific aspects of the 2023 waters rule to align with the Supreme Court decision in Sackett. That being said, Sackett decision has a real practical impact on the ground. Jurisdictional decisions regarding the waters of the United States that receive federal protection are made at the request of individual landowners or on a case-by-case basis using site-specific information. There are no maps or data sets that depict all waters that are or are not jurisdictional under any definition of waters of the United States. The EPA and Corps are still evaluating the impacts of the Sackett decision in terms of scope of jurisdiction. It is clear that the Supreme Court decision arose long-standing clean water protections. As a result of the Sackett decision, several types of waters may no longer be under federal protection. Estimates of ephemeral streams that could be affected range from 1.2 million miles to 4.9 million miles. Up to 63% of wetlands by acres are potentially impacted, as mapped in the United States by the U.S. Fish and Wildlife Services. Next slide, please. In terms of next steps, the agencies plan on hosting listening sessions this fall with co-regulators and stakeholders, focusing on identifying issues that may arise outside the limit of the rule, conforming the definitions of waters of the United States to the decision in Sackett. Please continue to check EPA's website at epa.gov/WOTUS for forthcoming details on listening sessions. You can also find the conforming rule, a fact sheet, and a red line of the amended regulatory text on EPA's website. To conclude, I'd like to emphasize that EPA is committed to strengthening our partnerships with states and tribes to support their efforts to protect waters for the people and communities that depend on them. Thank you for today's presentation, for allowing me to give today's presentation.
Thank you so much, Brian. We really appreciate that context and for you laying the groundwork for this webinar and telling us how this rule was developed. And I really appreciate that last statement of continued commitment to work with states and tribes. I'm sure there are going to be some questions from the audience, and we'll take those at the end, but thank you so much for your presentation.
Thank you.
And we're going to turn next to our next panelist, Roy Gardner. He's the co-director of the Institute for Biodiversity, Law and Policy and professor of law at Stetson University College of Law. He's going to be discussing his perspectives on the impacts of Sackett and the conforming rule, and providing some examples of what categories of water may not be protected any longer. So on to you, Roy. Thank you so much.
Hey, thanks, Rebecca, and good morning, good afternoon to everyone, wherever you might be. And thank you, Brian, for setting the stage for not only for my remarks, but the remarks of the rest of the panel. And it's I should preface this by saying that these are my own personal pessimistic views. At this particular moment, they don't necessarily reflect or represent the views of any organization with which I'm affiliated or may have represented in the past. So it's a pleasure to be here, although I wish it were under different circumstances. This is a picture of me in the Western Everglades in Big Cypress National Preserve. And so is this a water of the United States? Well, according to the Supreme Court, it might not even be a water. But it does not have a continuous surface connection to a larger water body. So spoiler alert, no. And I should note at the start here that the agencies are playing the hand they were dealt. They don't really have much flexibility here. They're just following the Supreme Court's lead, and the Supreme Court, in adopting the test that it did for whether a wetland is considered to be a water of the United States and therefore deserving of Clean Water Act protection, the court rejected precedent, Riverside Bayview Homes, disregarded the overall objective of the Clean Water Act in Section 101A, and ignored science. So I sympathize with the agencies for having to respond to this. Let's see if you could advance my. There we go. So let's compare the holding, or part of the holding, in the holding with part of the rule change. And so in this summary by Justice Alito, there are actually two parts. You have the continuous surface connection requirement, but then also you have this indistinguishable requirement that the wetland not only has to have a continuous surface connection, but it has to have this connection so that they're indistinguishable from the other waters. The rule addresses the first part, the continuous surface connection, but there's no mention in the rule or in the preamble with respect to what does indistinguishable mean. And again, I'm sympathetic to the agencies because this is a made-up standard. There's no basis in law, policy, practice, or science to come up with a standard about indistinguishable. But that is what the Supreme Court has decreed. My slides don't seem to be advancing. If you could advance them, please. Thank you. So there are lots of different ways to clarify wetlands. And the 2015 connectivity report that supported the Obama administration's Clean Water Rule, as well as the Biden administration's first revised WOTUS rule, divides wetlands into non-floodplain wetlands and riparian floodplain wetlands. So what's eliminated by the continuous surface connection requirement? Well, first of all, the non-floodplain wetlands are gone. So that includes prairie potholes, Pecosins, vernal pools, Carolina and Delmarva bays, just to name a few. In addition, riparian and floodplain wetlands that have a surface connection to an ephemeral stream are no longer jurisdictional, and that's because ephemeral streams themselves are not jurisdictional. And then any riparian or floodplain wetlands that only have a groundwater connection to a traditional navigable water or larger water body, those are also out. And as you heard Brian say, that up to 63, EPA is estimating at this point that up to 63% of wetlands are no longer covered, as 63% of what the U.S. Fish and Wildlife Service has mapped, which I think means the lower 48. But in any event, it's a big number. Next slide, please. Here's where it gets worse. Because if we take into account this second part of the test, and there hasn't been a lot of attention on this point, this indistinguishable, where it's difficult to determine where the water ends and the wetland begins. This is not a mere rhetorical flourish. This is part of the holding. And it's repeated a number of times in the opinion. Actually, the opinion repeats in sum with the holding 2 times. But in this summary of the holding, the court makes it clear that the wetland has to have a continuous surface connection, making it difficult to determine where the water ends and the wetland begins. So what's the impact of that? Next slide, please. Well, here's what we said in our amici brief in Sackett that we filed on behalf of 12 scientific organizations. It's not that difficult to determine. Generally, it's the limit of wetland vegetation, which is a function of water depth. And in practice, it's not difficult. In permit applicants on Corps of Engineer forms have to separately identify the project's impacts to wetland acreage and the project's impacts to streams in terms of linear feet. So there's a distinction made there. Corps public notices for permit applications make a distinction between wetland and stream impacts. The 404 mitigation program distinguishes between wetland and stream impacts and credits. Property owners will likely say, hey, if I can delineate the wetland, it's not jurisdictional. And if that's the interpretation, that would eliminate the vast majority of wetlands from any Clean Water Act protection. So I would be pleased to hear about another interpretation of what indistinguishable means. Next slide, please. So this is back in happier days where I am with my students in the Western Everglades in Big Cypress. We're hip deep in a cypress dome. Is this a water of the United States? Next slide, please. No, it's not, because, as I noted earlier, there's no continuous surface connection, and there's actually a road that separates it from other waters. So even if you can consider that to be a water, relatively permanent, it does dry up, though. There's not this continuous surface connection, and thus it's not a WOTUS. If old timers like myself might recall that back in 1991, the Bush administration had started a rulemaking with respect to wetland delineation and didn't complete it, in part because it was very controversial, because under that approach, 100,000 acres of the Everglades would not be considered to be wetlands. This is a magnitude worse. Essentially, we've got Everglades National Park, which the United States has designated as a wetland of international importance under the Ramsar Convention on Wetlands, but we're also saying most of it's not waters of the United States anymore. All right, well, what does this mean? Next slide, please. Well, a number of environmental groups have come out and said, well, it's going to be more than 50% of wetlands that are no longer protected. But as I note, I think it's worse than that, because number one, those groups don't want to undercut their litigation position, and they also wanted to wait until the EPA and the Corps issued the new rule. And the agencies are estimating up to 63%, but again, I'd like to know whether that takes into account the second part of the test, the requirement that it be difficult to determine where the water ends and the wetland begins. This is from a Clean Water Act coverage, worse than the Trump administration's Navigable Waters Protection Rule. Under the Trump administration, adjacent wetlands that abutted a WOTUS that were inundated in a typical year were covered. You didn't necessarily need a continuous surface connection. And in some circumstances, they could be physically separated by natural features or even a road. Does not appear to be the case anymore. So what does that mean if there is no Clean Water Act jurisdiction? Well, then there is no need for a permit, a federal permit. And, that's 402 and 404. Even if these waters were the subject of a previous denial or an EPA veto. So that might be interesting with respect to taking a look at the Bristol Bay veto. It also means that there's no jurisdictional hook for the states to weigh in, and so if there is no federal permit that's being required, then the states will not have the opportunity to participate through Section 401 and deciding to issue, deny, or otherwise condition a water quality certification. Next slide, please. It also has implications with respect to water quality standards, and I'll give one example here, which Edward might follow up on. But in Florida, in the Everglades, we have a state water quality standard of 10 parts per billion for phosphorus, and the driver for that was the Clean Water Act and the fact that the receiving waters were WOTUS. They're not anymore. So Sackett and the rule removes that driver for those water quality standards. So we'll have to see how that plays out. Also, if there's no need for a Clean Water Act permit, that means there's no need for those projects to purchase mitigation credits, no need to provide Clean Water Act offsets, and thus there's no need to obtain federal mitigation credits. And we'll hear more about that shortly from Greg. And so if you're in the mitigation banking business, I think it's depends on which state you're in terms of whether the state has its own independent wetland or stream protection program and how that might affect your credits. So bottom line is that the responsibility for wetland protection has shifted to state and local governments. From my perspective, Sackett, it's an extinction level event for the federal regulation and protection of wetlands, at least for non-tidal wetlands. So the responsibility is shifted to the state and local governments, and the early returns are not positive. North Carolina, for example, has weakened its state wetland programs, and we see here in Florida that individual counties, such as Manatee County, is backing off of its wetland protection rules. So that's where we are, and I look forward to someone talking me off the ledge here and providing us some more positive news. Thanks so much.
Yeah, thank you so much, Roy. I really appreciate you teeing up some of those issues that will come up a little bit later as well. So thank you for your perspective. We really appreciate it. And we're going to move on now to Greg, and I know there's some questions coming in, and we will get to those. So thank you for doing that. Keep them coming. So Greg, our next panelist is Greg DeYoung. He's the president and a board member of the Ecological Restoration Business Association. He's going to provide us with a practitioner's perspective on the conforming rule and the implications of Sackett, and in particular, the potential impacts to the compensatory mitigation industry. So thank you so much, Greg, for being here. We really appreciate it. Greg, are you able to? I see you. Oh, here you are. Okay.
It's not allowing me to start the video.
Oh, okay. We can
Greg,
hear you.
try again just now. We just did something on the back end that should fix it.
Perfect. Well, let me start by saying I had meant to to advise Roy to not hold back on his opinions, but obviously there was no need for me to say that. So I'm glad about that. I do want to say to the Environmental Law Institute, thank you. Thank you for hosting this webinar. You've pulled together an auspicious group of panelists to help us understand this particularly inauspicious point in time when in the whole 51-year history of the Clean Water Act. I'm with a practitioner, a wetland mitigation practitioner, and a species mitigation practitioner called Westerville Ecological Services. I'm also part of, I'm on the board and president of the Ecological Restoration Business Association. And I have three things that I want to discuss today. The first is the impact of Sackett on our industry. Then URBA's initiatives to on the WOTUS front. And finally, some thoughts on a silver lining. And it does not seem to be advancing, so if you could advance to the next slide. Thank you. URBA's mission is to support private investment in durable environmental results that enable responsible economic growth. Our 80 member companies provide compensatory mitigation for impacts to wetlands and waters of the US, as well as other offsets. And we do have a depth of experience. We have many of our members have 2 to 3 decades of dealing with different chapters of the whole WOTUS saga. Next slide, please. To date, our members have helped to restore hundreds of thousands of acres of wetlands, tens of thousands of stream miles, and interestingly enough, the sector, our industry sector, it generates approximately $25 billion in annual economic input, and it supports over 126,000 jobs. So that puts us, in terms of employment, that puts us as a sector right up with American traditional employment sectors. Next slide, please. The question, of course, is what about our effectiveness after Sackett? As, of course, there's a lot of uncertainty right now as the amended WOTUS rule is implemented and litigation continues. So the question is, how many acres of restored wetlands? How many miles of restored streams? How many dollars of annual economic output in our fairly major sector? And how many jobs will we be able to support? Next slide, please. But first, before I talk more about the impacts on our industry, I do want to talk about just one practitioner's, my point of view on what happened with Sackett. And what we've seen is that Sackett strips away the ecological tests for waters. And by cutting away these ecological tests, it really leaves a void. And just as an example, and again, I echo Roy's point that this is not really the initiative of the agencies, but this is what has needed to be done. And so I'm specifically putting here the excision that happened with the WOTUS rule. And so what's being removed is this idea of significantly affecting the chemical, physical, or biological integrity of waters. And what's left is a collection of features or physical indicators that really focus on navigability. Well, practitioners who have been out in the field a lot really know that this whole question, this whole endeavor that we all participate in it's about way more than just navigability. And so we do have a void, and practitioners have seen situations where watershed integrity can unravel because of the loss of integrity, the physical, chemical, and biological integrity. And that can really have significant effects on water quality, flood management, species status. There also, in terms of this void, with the void, there will be different responses, as Roy mentioned, from different states, and this really has a potential for inconsistency and confusion. Next slide, please. So, in terms of impacts of on our industry, the issue is with a narrowing wetland footprint, there will be less wetland protection, less permitting, and less demand for compensatory mitigation. And if you could press the next slide, please. And so in the interim, we are going to have uncertainty and inconsistency. We're also going to have something called stranded credits, or what we refer to as stranded credits. And those are credits, I'll talk a little bit more about that, but those are credits that have already been approved under the prior version of WOTUS. But there's some discussion that maybe those should no longer be as applicable or even applicable to impacts to the newly crafted jurisdictional wetlands. So again, stranded credits. And then all of this uncertainty, of course, can lead to unfavorable conditions for investment. Next slide, please. This slide actually was inspired by Roy, and I've had the thoughts, or this quote from Mark Twain has occurred to me before, but I think it can apply to our industry, that the reports of our demise have been greatly exaggerated. Part of the reason why we say that is we've had threats before. I know this one's significant, but we've always been able to figure out a way to deal with these challenges. But also there is consistent public support for ecological restoration, and that's shown in polls. It's revealed in the bipartisan infrastructure bill and other administration initiatives. Next slide, please. So here we are all over again. And this slide really speaks to some of the challenges that we've been able to overcome in the past. Most recently, the Navigable Waters Protection Rule, where vast areas were removed from jurisdiction. That was a crazy time, and yet our industry still not just survived, but actually continued to grow. And then looking back at 2008, which has timelines in it, but they've proven to be very elusive. And so even to this day, we have a very difficult time understanding and managing what returns on our investments are going to be. So it's been a crazy time in that regard too. And then scrolling way back to 2001, some of you may remember the National Academy of Sciences report. An interesting fact for me was that a lot of the failure, about 1/3 of it in terms of wetland mitigation, happened because the projects were never implemented in the first place. And for a mitigation provider, it's really hard to compete with the very low cost of doing nothing. And so that was a crazy time. We've had crazy times, we're back here again, and yet we feel optimistic, guardedly optimistic, that we're going to be able to continue. Next slide, please. And so again, member input reveals a guarded optimism. Some of the comments are, we have been here before, and this is the nature of our business. There is always a new problem to be fixed. And then most importantly, how do we move forward? Next slide, please. I want to just provide, this is not a scientific survey, this is just a snapshot, but the next few slides just touch on what some of our members in different parts of the country have been saying. And so in terms of California, it was interesting. They're saying that major infrastructure clients are actually forecasting an increased need for mitigation and not a reduction in impact. And there are various reasons for that. One of the reasons for that is in California, there's pretty robust policy and law that I think will fill in the gap for federal protection. But also in California, we have a version of the Endangered Species Act that has and will continue to compel mitigation. Next slide, please. In Colorado, they have already implemented an enforcement policy. It's an interim policy that is intended to protect wetlands while the state develops a broader program. I also want to mention that the person that I contacted in Colorado is quite concerned about ephemeral features in the arid West as falling through the cracks. Next slide, please. And in Texas, this is where this issue that I referred to earlier as stranded credits may be surfacing. We don't really know, but we've heard some rumbling that the Corps in that area may reevaluate approved credits that were based on wetland restoration of areas that were considered previous to Sackett, they were considered jurisdictional, but they would no longer be considered jurisdictional under the new WOTUS rule. And so there's quite a concern about this idea of stranded credits. Next slide, please. And then in the Southeast, interestingly enough, we're not hearing that same thing about stranded credits. In other words, we don't believe that there will be an effect on the use of credits that now are considered non-jurisdictional. Also, there was a comment that in terms of new investment, that the position of states, the policies of states in terms of wetlands really will make a difference. And one of the states that was brought up as being potentially favorable was Florida. Next slide, please. In terms of something that we're hearing in multiple places, and this is really, again, a snapshot, it's just what's happening right now, but right now, in multiple locations, permittees want to continue moving forward as with their projects as previously planned and permitted. They're concerned about the uncertainty and potential delays associated with reopening their permits. Also, I think in terms of this, and I think Roy touched on this too, but there is some concern that even if we're successful switching our focus to state level protection of wetlands, that we need to be mindful that doing rigorous wetland compensation could be politically unpalatable in a lot of states. So that's something that we need to be thinking about. Next slide, please. Going forward, our industry is going to need working definitions of these terms and more: relatively permanent flow, continuous surface connection, how far up a tributary will jurisdiction extend. And then this is a focus for us, and I'll talk a little bit more about it, but the 2008 rule has a concept, the 2008 compensatory mitigation rule has a concept called the watershed approach. And we are very curious and seeking some guidance on how compensatory mitigation going forward can fit into this idea of the watershed approach. We understand that there, and we heard before that there will be region-specific guidance, and we really look forward to participating and input to that regional guidance. Next slide, please. Getting more to the meat of what IRBA is actually doing, we look forward to working with the agencies, and we've already started by requesting guidance on these three items that you see here. And the first one is the use of non-jurisdictional mitigation bank credits to offset impacts to post-Sackett waters. And this, again, this speaks to this whole idea of stranded credits. The point I really want to make here is this is already permissible. In other words, even before Sackett, even before the revised WOTUS rule, the 2008 mitigation rule explicitly allows the use of restored non-jurisdictional features to be used as credits to offset impacts to jurisdictional. This is even more important going forward just because of this narrowing footprint of wetlands. So we're requesting guidance on that, and we have issued the document that has a screenshot here, and the document is called the Need for Guidance on Application of Non-Jurisdictional Credits. The second thing we really need guidance on is the use of mitigation bank credits for purposes outside of the narrowing realm of the Clean Water Act. And what I mean by that is this is something that already is happening in some parts of the country, and it's especially happening with the Endangered Species Act. In other words, a single mitigation bank can be approved for offsets to wetlands and waters, and it can be simultaneously in a comprehensive way approved for impacts to species. And we're asking for specific guidance on that because we need the flexibility of being able to use these credits for multiple purposes. Again, it is happening in many places. There are some districts, though, that specifically will not allow that. And the attitude seems to be that, no, these are our credits. So this is something that we hope to interact with the agencies on going forward. And then again, regional specific guidance. We feel like our practical experience could really contribute to any region specific guidance. We're also advocating for wetland protection in states and other federal authorities beyond just the Clean Water Act. And then finally, diversification of markets. There is an opportunity to apply all of these skills that we've been developing under the Clean Water Act to a whole host of different ecological restoration needs. They include species, again, water quality improvements, and biodiversity issues. And we already are making a lot of progress in this arena. In fact, some of our members are doing water quality projects that measure in the thousands of acres. So we're looking forward to diversifying our markets. Next slide. I'm going to leave on a positive note, or at least the idea of a positive note. And that, again, is getting to this idea of watershed approach. So what has happened, as we've all talked about, is that this idea of significant nexus has been excised from just the footprint of waters of the US. But again, the watershed approach, which is in the 2008 compensatory mitigation rule, has an actual emphasis on interconnected aquatic features. And so that still exists as a standard for compensatory mitigation. So what we're seeing is compensatory mitigation should be able to play a critical role in the watershed approach. And so this is a way, we think, to get back to this idea of chemical, physical, and biological integrity of waters. We're suggesting that not just practitioners, but agencies and others actually lean in to this idea of the watershed approach. And this may involve restoring features that are no longer considered jurisdictional, but are important connections to jurisdictional waters. And I'll leave with this vision that this is an opportunity to navigate the post-Sackett waters for permittees, practitioners, stakeholders, and watersheds. Thank you.
Thank you so much, Greg. We really appreciate that. Your perspective, I really appreciated hearing from your contacts and colleagues from across the country and their perspective of what's immediately happening. And I really like the ideas on the watershed approach. So more on that, I'm sure. We're going to turn to our next panelist, and thank you all for putting the questions in the chat, in the Q&A box. That's great. We really appreciate that. We'll come to those right after we have our final speaker, Edward Ornstein. He's the Special Counsel on Environmental Affairs for the Miccosukee Tribe of Indians of Florida. He's going to be providing another kind of stakeholder perspective on the conforming rule as a tribal member and special counsel for the tribe, with a focus on the rule's impacts to the Everglades and his practice. So Edward, thank you for joining us.
Thank you for inviting me, and good afternoon all. My name is Edward Ornstein, and I'm a citizen of the Southeastern Muskogee Nation, a state-recognized tribe in Alabama, and I also serve as the Special Counsel on Environmental Affairs for the Miccosukee Tribe of Indians of Florida, and as chair for the American Bar Association's Indigenous Law Committee, organized within the section of Environment, Energy, and Resources. I'm really happy to be here and share a slightly different perspective from Indian country, noting, of course, that the views I express are my own. To begin with, I think it's worth making sure that everybody has a clear picture in their head of what we're talking about when we refer to tribal nations. If you compare the Obama-era wetland delineations and the locations of federally recognized tribes within the United States, you'll notice that pretty much everywhere there's wetlands, there's tribes. I'm sitting in the center of the Everglades within the Miccosukee Tribe of Indians of Florida's jurisdiction. If you're looking at the map here, very southern tip of Florida. So with the understanding that wetlands are Indian lands, let's discuss what that means. For those unfamiliar with federal Indian law and who have not worked with tribes in their practice, tribes are not just reservations. They are national bodies, and they are recognized as such by a very long line of cases, going back to the 1820s and 1830s, with a trilogy of cases, sometimes known as the Marshall Trilogy, after Chief Justice John Marshall, Cherokee Nation versus Georgia, Worcester v. Georgia, and Johnson v. McIntosh, all the way through the present day with cases like Santa Clara Pueblo v. Martinez, California v. Cabazon, or McGirt v. Oklahoma. These cases, which I would be doing a disservice to attempt to summarize here, make it clear that tribes are sovereign nations, invested with all of the aspects of sovereignty that have not yet been explicitly divested by Congress or by the tribe itself. Therefore, and this is explicit in the case law, Tribes are sovereign nations. The precise term is a domestic dependent nation whose regulatory authority is more often than not exclusive of state authority. I would highly encourage anyone in the environmental law practice to dig into these cases and other related cases, knowing their relevance to the management of, and particularly the conflict of laws within, almost every watershed in the United States. With that basic foundation established, let's dive into how the conforming WOTUS rule may impact tribal nations. So the conforming rule provides further certainty about the outcome of Sackett, but it's still not the final word on the matter, as several of my colleagues have noted today. There are still many open questions which require resolution, and that's what I'd like to focus on, having already heard such excellent commentary on what the rule does tell us from my esteemed colleagues. First of all, how will individual watersheds be regulated? How will the conforming WOTUS rule trickle down to each locality? The Army Corps in the various districts has an opportunity to make these decisions on a case-by-case basis. Noting, of course, and we've heard this statistic as well from other presenters, that the Wildlife Society and the EPA suggests that about 63% of wetlands will be federally deregulated. Another good question is, how will wetlands divided by artificial structures be regulated? The preamble of the conforming rule does touch on levees, dikes, and berms, but what about a flow gate? We've got a lot of those here in the Everglades, and if a flow gate is open, then there's a continuous surface water connection. If there is a rulemaking that causes that flow gate to close, then that continuous surface water connection would be severed. So I hesitate to make any prediction about the implication of the conforming rule on any specific wetland like the Everglades where I work. But it is safe to say that these places are in jeopardy of federal deregulation. But there's policy yet to be developed, and it is quite possible that physical alterations to a watershed may change their potential for regulation. For example, in Professor Gardner's slide, we were shown a cypress dome off of Gator Hook Trail. Gator Hook Trail is, separated from the rest of the Everglades by the Tamiami Trail, which is a highway, US 41, which bisects Florida from east to west. Right now, the Western Tamiami Trail is primarily continuing the flow of the Everglades through culverts, which are inserted below the roadbed. But what if, as some advocates are pushing for, that trail had bridges instead of culverts? Would that water then become jurisdictional? Are there physical changes to the landscape that might shift the jurisdiction of waters? And do, under the Administrative Procedure Act, these agencies need to take into account the impacts of their rulemaking on the physical map of waters of the United States? I think that's worth looking into. And even if there are not surface connections, what's the lag time for an impacted water to cross from one body to another? While the Supreme Court doesn't necessarily acknowledge this, I think most of the folks in this call are aware that, surface waters are connected to groundwater, and that groundwater does allow the transfer of nutrients and pollutants from one surface body water to another. And this is something that the Supreme Court has thought about in prior sessions in the county of Maui, where this logic was applied to NIPD's permitting. Is that a logic that we can extend here? How do we, as attorneys, create the connectivity in order to make that case? And what is the impact specifically for a tribe or state which has assumed regulatory authority from the EPA? And does there need to be any impact if the tribe or state fills gaps in that regulatory scheme? So the conforming rule in the preamble specifically does consider the impact on states and tribes administering Clean Water Act programs. And I think it's worth reading that language together with the statement of Alito in the Sackett decision, where he says states can and will continue to exercise their primary authority to combat water pollution by regulating land and water use. Clearly, this is kind of going to become a federalism discussion. I think it's fair to say that folks at the intersection of policy analysis and GIS mapping will be making a lot of money over the next couple months as stakeholders try to map out what is or is not a jurisdictional water, what does or does not need further regulation by a different sovereign authority. And I'm sure the various districts of the Army Corps will be equally as busy. So I think it's worth us going beyond this paradigm of delegated authority and looking, especially from a tribal government perspective, at the inherent sovereignty of tribes and states to regulate these watersheds. So, it is true that Florida's EPA delegated Clean Water Act authority and the Everglades may be in jeopardy. It is true that my employer, the Miccosukee tribe, may face challenges in implementing their Clean Water Act authority, totally dependent upon decisions made by the Army Corps, which have not yet been made. But there is no reason to think that either sovereign body could not regulate of their own accord, according to their own sovereign authority, waters that are within their jurisdiction if determination is made by an Army Corps district that those waters are no longer jurisdictional waters of the United States. I think it's worth noting that there's been a little bit of press about this decision and its implications, and the Secretary of New Mexico's Environment Department has spoken very specifically to what the financial implications would be for his state. Notably, it's projecting $6 to $7 million of additional annual costs, covering the hiring of about 40 to 45 new staff members. These numbers are, of course, locally specific, and a small tribe executing regulations will need a smaller staff than a large Western state, the waters of which have likely been largely deregulated by the conforming rule. But the case of New Mexico gives us a window into the financial implications of the new conforming rule. It's not a matter of whether or not these waters will be entirely deregulated. It's more a matter of who will be assuming the cost of regulation. So in that context, I think this is a jurisgenerative moment in the history of environmental federalism for states, but for tribes too. While we wait for the courts and the agencies to provide more clarity on relative permanency and all of the other new key words that we're focusing in on after the Sackett decision and the release of the conforming rule, we can anticipate that states and tribes will need to begin filling gaps in the regulation. And we can start thinking about how we might approach that. To that end, we need to broaden our toolkit. I think there's an opportunity to get a little bit more fluent in the functional equivalence test from the County of Maui. I think this is an opportunity in, acknowledgement of the fact that states will be assuming a lot more of this authority within their jurisdiction to shift some lobbying resources, advocacy resources from national governments to state governments. And I think if you're a tribal government, this is a great opportunity to establish tribal jurisdiction to regulate. Tribal civil jurisdiction over non-tribal members is governed by the test established by the Supreme Court in 1981 in Montana versus the United States. In that case, the court said that tribes are presumed not to have civil regulatory authority over non-members unless, 1, there was consent to that jurisdiction, 2, there's an existing agreement between the party that is attempting to regulate and the party which is to be regulated, and 3, if the party to be regulated poses a threat to the health, welfare, or political integrity of the tribal nation. And I think when we're talking about impacts to water quality, that's a very easy case to make. And when all else fails, we have to look back to where our field of environmental law began, in mass torts. If someone's releasing something into a water, if someone's damaging a wetland, and there is an injured party, that party still has standing to bring a claim and attempt to enjoin the action. So I don't think we are in the middle of an apocalypse, but I think we are in the middle of a major reevaluation of the tools that we can use to affect the same change, same protection, and same oversight over the wetlands and waters that are potentially deregulated by the conforming rule. Thank you all.
Thank you so much, Edward. We really appreciate that perspective. It's extremely important, and I agree. These are the areas that we're going to need to explore as we move forward. I do want to move on to questions, and I have a few I'm going to start with, but we do have a number in the Q&A, and I'm gonna try to cover those as I start with the questions. But I do have a couple of questions first for Brian, and given that the rule went into immediate effect, and there's folks on the ground in the districts making decisions on JDs and permits, and as we can see reflected in the Q&A, there's lots of questions on things like what's relatively permanent, how do we assess continuous surface connection. So I don't know what you can answer there, but maybe what you can tell us a little bit more about is what the agency's plans are for future rulemaking or guidance that you're going to get out to the stakeholders and the core districts and the states on all these remaining implementation questions and the nuances of what came down through Sackett.
Yeah, so in terms of moving out with another rulemaking, the agencies are committed to addressing other issues that may arise outside the scope of the limited rule. We're also hosting public webinars, and we had 2 already, and we have another one coming up on the 20th of September to provide updates on the definition of the water of the United States. The webinar will be, that we did on the 12th, I believe, was recorded, so folks want to see that. But we have no plans on doing another rule right now, so that's what I can kind of make folks aware of.
Great, and then maybe in terms of future guidance, are those things that you're going to develop as you do stakeholder input meetings over time, or do you have input already that there's specific issues you're going to cover?
Yeah, we will be doing internal guidance with our field staff, and then eventually we would go out with training for states and tribes as well here in the near future. As I said, we have a listening session that's coming up pretty soon that we will also be taking feedback from folks as well in terms of moving forward in implementing the regulation.
Great, thank you. And I do want to ask one more question, because I know you covered some of what's going to be happening moving forward in terms of jurisdictional determinations, and that the core districts are now moving forward and making those. But how does this new rule affect currently approved or just jurisdictional determinations that were approved under the January 2023 rule or the pre-2015 regulatory regime, and
again,
and as well as permits that were approved?
Understood. Permit decisions that relied on the AJD completed under the January 2023 rule or the pre-2015 regulatory regime will not be reconsidered. The Corps may rely on the AJD issue under the January 2023 rule or the pre-2015 regulatory regime, completed prior to the date of the Sackett decision to support pending or new permit decisions where requesters wish to do so. However, in these circumstances, I do want to make clear that the Corps will discuss with the applicant, as detailed in the regulatory guidance letter 1601, whether the applicant would like to receive a new AJD under the current regulatory regime to continue their permit processing, or whether the applicant would like to proceed in reliance on the existing AJD, preliminary JD, or the JD, or no JD, I'm sorry.
Great. Thank you so much. I think that's really useful information. Thank you for providing that. Roy, I know there were some questions in the chat about culverts, and if culverts are enough to indicate continuous surface connection. And you noted that maybe you'd want to answer that live, and I'll give you a chance to do that. And then I have another question for you as well.
Yeah, well, I hit the link because I thought I could type an answer in, but so if you have a culvert, is that a continuous surface connection? I'm not sure. It may depend on the circumstances, whether there's a continuous hydrological connection. Whether it's surface or not, I don't know. But in those circumstances, I would ask you, can you distinguish the wetland from the other water body? If you can, the Supreme Court quite clearly said The wetland is not a water of the United States.
Ed, did you want to comment on that, or others? You mentioned that as well.
I think it's a fascinating question, and it's one that I hope is resolved in a positive way. I could certainly make a case for water flowing through a culvert being a surface, maybe not the surface that the Supreme Court was envisioning, but I think there's an opportunity for Army Corps districts for further guidance from the EPA and Army Corps headquarters to weigh in on this issue.
Thank you for that. And maybe, Roy, I'll ask you briefly, because we haven't touched on it too much, but the removal of interstate wetlands from the category of interstate waters, what does that mean kind of practically on the ground, and especially as we've talked about in places where you might have, a wetland crossing estates with different kinds of protection programs?
So if these interstate wetlands do not otherwise qualify as an adjacent wetland, then they're not protected by the Clean Water Act. If one state, we were discussing the boundary between Minnesota and Iowa. Minnesota actually protects its wetlands. Iowa, not so much. And so if one state took action to degrade its wetlands, the remedies may be rather limited to the other state. I mean, certainly there'd be no remedy that I see under the Clean Water Act if those waters are not WOTUS.
Thank you, Roy. Greg, I wanted to ask a little bit more about how practically on the ground from your practitioner's perspective, and given that this rule is likely going to be subject to more litigation and may make this patchwork even more confusing, what are you seeing kind of moving forward, and how does your industry kind of address this nationwide patchwork of regulatory regimes at the state and federal level?
I think it's a great question, because I think there's a presumption that what has happened with Sackett is automatically good for our clients, our normal clients, for permittees, and clearly it was good for the Sacketts. But what you're pointing to, I think, is problematic. I think it's going to be a big issue, and part of that is a lot of infrastructure providers, even a lot of large corporations, they rely on consistency. They actually thrive on consistency and clarity. And I think I just don't see a future where we will have consistency and clarity, because I think we may have states that are side by side with dramatically different rules. And so that's where I think, again, I think there's a void, because I think that the ecological piece of this was cut out of the footprint of WOTUS, and so I think I don't have an answer to that, other than I do think we need to start thinking about the future, and not just because this is my industry, but I think we need to figure out, how do we compensate for impacts to this narrowing footprint, because there still is a need for physical and chemical and biological integrity. There absolutely is. And so we need to collectively figure out, okay, there's a narrowing footprint, probably less specific instances where there's going to be a trigger for compensatory mitigation. But when there is, we need to figure out, how do we get back to this idea of ecological integrity? And I think it's possible. I just think it's going to take a lot of thought on how we get there.
Yeah, for sure. And we have a number of the smart people on this webinar that can start thinking about that. Appreciate that. Edward, I wanted to follow up a little bit on kind of your last slide on thinking outside of the box, and especially, you know, where you work in the Everglades, and there is a real federal investment in that area and protection and restoration. And, you know, there are other examples of that across the country, Chesapeake Bay or the Great Lakes. So are there opportunities for using those kind of programs to make sure these areas are continue to be protected? Or maybe more broadly, what are these other kinds of opportunities? And maybe Greg or Rory or Brian, you want to add to that too. What are the other opportunities for thinking about other kinds of programs that may help provide protection or help restore these wetland areas?
Sure. So if you're unfamiliar with the Everglades was historically the widest river in the world. Historically, probably a very clear case of a water of the United States. And it would flow from north of Lake Okeechobee in the sort of chain of lakes regions, down through Lake Okeechobee along the Kissimmee River, and then from Lake Okeechobee out west through the estuary, out east through the estuary, and south all the way to the Florida Bay, where the Florida Keys kind of hang out as barrier islands. Now, over the course of the past century, beginning with Governor Napoleon Bonaparte Broward, we always know there's something crazy coming when a Napoleon is involved. The Everglades has been massively compartmentalized. There are now some over 2,100 miles of levees, berms, and dikes, over 2,100 miles of canals. And the only reason, in my mind, that we're facing a situation where there is a potential for the deregulation of parts of the Everglades are those very same artificial features. Now, you're right in pointing out that there's a lot of more modern investment in Everglades restoration. Congress, through the Water Resources Development Act, approves a variety of appropriations for the Comprehensive Everglades Restoration Plan, which is some, more than 50 or 60 projects which intend to address the issues created in Governor Bonaparte Broward's day. And many of those projects are actually seeking to remove those artificial impediments by filling canals and restoring sheet flow, by adding flow gates on levees, by degrading levees, and also restoring sheet flow. So those projects, kind of as I was hinting at when talking about the Tamiami Trail, are an opportunity to even reshape the legal landscape as it exists as a superstructure over the physical landscape, as a culvert goes away and is replaced by a bridge. That being said, these projects are also intimately tied into the Clean Water Act, and they rely on the requirements that are set under the Clean Water Act, the water quality standards, when doing their engineering and targeting outcomes. So I think there will need to be some degree of reevaluation in how those projects are executed, but those projects still pose an excellent opportunity for the continued restoration and improvement of the Everglades ecosystem. The way I see it, the main impact to the Everglades is probably on the periphery, where there are not a bunch of federal lands or tribal lands, and where there is some appetite for private development. The intersection with what Greg was discussing, the compensatory mitigation industry, is, I think, very significant. And I think we've yet to see how Congress, how the local Army Corps will respond to the conforming rule. And I think that response is ultimately going to be determinative of how future Everglades restoration projects interact with this complex legal matrix.
Thank you. Super interesting answer. So much brought up. Did anyone else have any comments on that?
Yeah, this is Brian. One thing I was thinking about too is, bolstering the state and tribal programs, and things that we have here, the tools that we have here at EPA is the Wetlands Program Development Grants, where we offer states and tribes, grants to protect and restore their waters. The other thing is our non-point source program, where we have 319 funding too. So those are things that I think that outside the box of the regulatory construct that we can also support protecting state and tribal waters.
If I could jump in there and actually, with respect to the non-point source program, right, I mean, states have always had the primary responsibility for dealing with non-point source pollution, and they don't do a very good job. So I'm not confident that with their new responsibilities that they're going to be stepping up to the plate. But in terms of trying to think outside the box, perhaps beyond the Clean Water Act, the Endangered Species Act might be used as a proxy for protecting wetlands and other waters. Of course, that may be subject to some litigation as well in the future. But there are also efforts in Florida, for example, in terms of actually purchasing environmentally sensitive lands or purchasing conservation easements with respect to environmentally sensitive lands that contain wetlands and other waters, and that may be something where there's more political support across both aisles. And then finally, taking a look at the private sector, and I think this was mentioned in the questions, a question about insurance companies. Case needs to be made about having wetlands in your neighborhood to help attenuate some of the flooding that we see here in Florida on a regular basis, and so the insurance industry may have a big role to play here. Thanks.
Yeah, I do have
sure.
one.
Go ahead, Brian, please.
I don't want you to put a broad brush over the United States, Royal. I think there are some states that do a really good job in non-point source protection. So I don't want that to be a broad brush, and maybe as you caveated your presentation, it's your opinion. So I do think there are some states that do a really good job.
Yeah, thank you, Brian.
I agree with that. But non-point source pollution in Florida is a huge issue, and the state has not stepped up to deal with that, especially with respect to the harmful algal blooms that we have here. Thanks.
An area for opportunity for future growth. Brian, yes, please. I know we have to wrap up because I know you have to hop off, but thank you so much for joining. Yeah, go ahead. Oh, okay. So I know we've gone 15 minutes over, and I so appreciate everyone still staying on the line. There were a number of questions I still wanted to ask. We didn't get to streams, and it looks like Greg made a head to hop off, and I wanted to ask him about intermittent streams, but maybe that's the focus of the next webinar. So thank you all to our panelists. I really appreciate your time and your flexibility today and giving us your great perspectives on this important area. And we hope to find ways to continue to provide all of you with more information and more good work from these panelists. Madison, is it time to turn it back over to you?
Yeah, sure.
All right, thank you all.
Thank you so much to everyone. Thank you so much to our wonderful speakers for taking the time to join us for the discussion on such an important topic. We really appreciate your insight and your expertise. We also thank you for sticking with us through our technical difficulties today. Also, I want to give a big thank you to our ELI Wetlands team who also helped us develop this program. For our attendees, as a reminder, if you didn't see our Sackett webinar, we have posted the link in the chat. The recording will be publicly available for the next couple of weeks for anyone who's interested. Today's event was recorded, so if you were unable to watch all of it, you'll be able to watch the recording on the event webpage within a couple of business days. Since we had so many technical difficulties at the start of this program, we will be sharing the recording with all registrants of the program through email, so please feel free to check your email and watch the recording later. Thank you to our audience for your time and engagement, and again, we apologize for technical difficulties at the first start of the program. Please be sure to check out eli.org for more information on all future ELI programming. We hope to see you at another event. Have a great day, and thank you again.
Thank you all.